I'm ready, yes.
All right, good morning. We are on the record. This is the evidentiary hearing in file number GR-2021-0320. It's in the matter of the request of the Empire District Gas Company, DBA Liberty, for authority to file tariffs increasing rates for gas service provided to customers in its Missouri service area. Good morning. I am Ron Pridgeon. I'm the regulatory law judge assigned to preside over this hearing. It's being held on April 25th, 2022. We are in the Governor Office Building in Jefferson City, Missouri, and also using WebEx for this hearing. The time is approximately 8:40 a.m. I would like to get entries of appearance from counsel. Symmetry has already asked to be excused from this hearing, and I have granted that request. So let me get entries of appearance from the parties, beginning with Empire District Gas, please.
Thank you, Judge. On behalf of Empire District Gas Company, let the record reflect the appearance of Diana C. Carter and James M. Fisher. Our contact information is on the entry form, but since the reporter's not in the room, perhaps I should go ahead and give you addresses. My address, it's the law firm of Fisher and Doherty, PC, 101 Madison Street, Suite 400, Jefferson City, Missouri, 65101. Ms. Carter's address is she's with Liberty Utilities in-house counsel, and her address is 428 East Capitol Avenue, Suite 303, Jefferson City, Missouri, 65101.
All right, Mr. Fisher, thank you. On behalf of the staff of the commission, please.
Good morning, Judge. On behalf of the staff of the Missouri Public Service Commission, this is Jamie Myers. My address is 200 Madison Street, Suite 800, Jefferson City, Missouri, 65101.
Ms. Myers, thank you. On behalf of the Office of the Public Counsel, please.
Nathan Williams, Chief Deputy Public Counsel, P.O. Box 2230, Jefferson City, Missouri, 65102.
Mr. Williams, thank you. On behalf of MSBA, please.
Yes, let the record show the appearance of Richard Brownlee. My address is the Gallery Level, 121 Madison Street, Jefferson City, Missouri. I'm appearing on behalf of the Missouri School Boards Association. With me today is Mike Parnell, Executive Director, and I have two witnesses. One is Louis Irvin Sr. and Louis Irvin Jr. Thank you.
Mr. Brownlee, thank you. On behalf of MECG, please.
Good morning, Tim Opitz on behalf of Midwest Energy Consumers Group. My address is 308 East High Street, Suite B101, Jefferson City, Missouri, 65101.
Mr. Opitz, thank you. Have I overlooked anyone? All right. I believe the first order of business then will be the order of opening statements, and I showed that Empire District Gas will be the first to make an opening statement. I'm sorry, anything further?
Judge, do you want to acknowledge the
I'm getting some feedback in the room. I'm not sure who's on. No? On a phone call?
Hey, Judge.
Okay.
Judge, do you want to acknowledge the commissioners in the room?
Yes, sir. I'm sorry. Is this Commissioner Holzman? I'm sorry.
Yes, it is.
All right. Let me see if there are any commissioners that would like to make any opening remarks before we go on to opening statements.
I just want the record to reflect which commissioners are present.
Very good, Commissioner Holzman. Thank you. I do hear Commissioner Holzman. Thank you, sir. Any other commissioner wishing to make any opening remarks? All right. Thank you. Anything further before we move on to opening statements? All right. Mr. Fisher, when you're ready, sir.
Thank you, Judge. Good morning, Judge Pridgeon and commissioners. Diana Carter and I will be representing the Empire District Gas Company, DBA Liberty in this case. As you know, Empire District Gas filed a rate case requesting a $1.36 million rate increase. This was the first rate increase case for the company since 2010. On April the 12th, the parties filed a stipulation and agreement which resolved all of the revenue requirement issues and all of the rate design issues in the case. And I understand we will be considering in an on-the-record presentation format that stipulation at the end of the hearing today. We were not able to settle the issues raised by the Missouri School Boards Association, and those issues are to be heard today. All of the issues involve the school transportation program, which EDG has been operating for about 20 years. The school transportation program has been working well from the company's perspective, but EDG is willing to work with the Missouri School Board Association and the staff and any other interested party to improve it as we go forward into the future. As Staff Witness Patterson points out in his rebuttal testimony on pages 8, 9, and 10, the issues raised by the association involve very little money on an annual basis for each school that participates in the school transportation program in a typical year. The association has proposed 3 changes to Empire's transportation service tariff. 2 of these would involve changes to the current commission-approved tariff that Empire has not proposed to change in the rate case. The association has also opposed one of Empire's proposed revisions to clarify that the ultimate customer is responsible to pay the bill if its marketer or aggregator fails to pay the gas transportation service, as what happened during that Winter Storm Uri in February of last year. But Judge, the company proposes at this time to withdraw that 3rd issue relating on our list of issues, issue 1C, which deals with the customer responsibility clarification language. We would propose to withdraw that, and it doesn't need to be heard at that time. And it's my understanding that no other party objects to that request. Both the company and the staff recommend that the commission deny the association's remaining 2 requests related to the transportation tariffs. And I'd like to just briefly go through the company's position on these 3 issues. The first issue involves the association's request to change Empire's existing aggregation, balancing, and cash-out charges. These rates were approved by the Commission in case number GR-2021-0434 and are just and reasonable. These charges came about as a result of a settlement in that 2009 rate case. There was extensive testimony on the transportation tariffs and fees from 6 witnesses representing Empire, staff, and a gas marketer company that supplied gas to transportation customers. The Commission approved the stipulation that settled the issue in that case and established the current fees for aggregation, balancing, and cash-out charges for small and medium transportation customers. These fees have remained unchanged for the last 12 years. As Staff Witness Patterson testifies, staff supports the existing charges for Empire, but he suggested that since these types of charges have not changed across the LDC industry for many years, they may not be high enough to cover the current cost of providing these services. Now, going to the cash-out and balancing issue. The association proposes to eliminate cash-out balancing and substitute what's called a carryover method, or in the alternative, eliminate multipliers applied to the pricing of larger imbalances. When the Commission reviews the testimony of Staff Witness Patterson on pages 8, 9, and 10, the Commission will quickly note that these issues involve small amounts of money. However, it will take some time, some effort, and expense for the parties of the Commission to reevaluate these charges in the future. The staff has also pointed out that the association's alternative carryover method has some problems for Empire and has only recently been adopted by Missouri's largest LDC, Spire, Missouri. Unlike Empire, Spire has its own on-system storage facilities and is considerably larger than Empire. There are also differences in the billing practices of the companies, which makes the School Board Association's carryover method less desirable for Empire. The staff has also recommended that the cash-out method should be the norm for other school transportation programs operated by all the other LDCs in Missouri. I refer you to Mr. Patterson's rebuttal on page 8, lines 3 through 5. Second, the association proposes to create a separate tariff that would apply only to school transportation pools, separate from the other transportation tariffs. Empire agrees that it would be helpful and appropriate to develop a separate rate schedule for the school transportation program schools. Eventually, Empire hopes to have a separate rate schedule for the school transportation programs for both the Empire District Gas Company and its sister company, Liberty Utilities Midstates, that includes the best practices for school transportation programs. However, we do not believe that it would be reasonable to merely adopt the standalone tariff that currently exists for Liberty Utilities Midstates, or to incorporate parts of that tariff into the EDG tariff at this time. The company believes that there needs to be a significant updates and other language improvements to the Liberty Midstate School Transportation tariff. Empire has had discussions with staff regarding some of these updates and improvements. We believe it will take some time to discuss the staff's perspective on these issues and develop and implement some of these changes. For example, we believe it would be appropriate to change the cash-out structure of the Mid-States tariff to be more similar to the Empire District gas structure, or some other type of cash-out structure that's acceptable to the association, the commission staff, and other interested parties. We would propose to begin discussing the provisions of the standalone tariff with the association and the staff and other interested parties sometime after the conclusion of this rate case, and have a revised tariff ready for the commission's consideration concurrent with Liberty Midstate's next general rate case. As you know, companies have to file about every 3 years in order to keep their ISRIS. And Liberty Midstates has an ISRIS. Their ISRIS was last effective in June of 2021, so they would need to file by 2024. Thank you for your attention today. Judge, I would take any of your questions, and if not, I'll be done.
All right, Mr. Fisher, thank you. Let me see if we have any bench questions. Commissioner Holzman, any questions? Okay, I don't hear anything. Commissioner Holzman, if you have any questions, feel free to let me know. Otherwise, Mr. Fisher, thank you.
Thank you.
Hey, Judge, I got no questions, but it makes me *6 every time I want to try to unmute. So unless I unmute, I don't have any questions.
All right, thank you. Opening statement then from MSBA.
Good morning, Judge and Commissioner. I'm Richard Brownlee. I'm representing the Missouri School Boards Association. I had briefly thought over before coming here that I think my first Public Service Commission case was in 1974, which it's me getting close to 50 years over here, so it's probably time. This may be my last case, as well as being able to talk about the first case. But in any event, let me talk about this a minute. And I first would like to comment, having at least some experience with lots of different cases, water cases and gas, electric, that this case, for as simple as it is actually, it's in a way complex, but we are also sort of trapped in the procedural conundrum of rate cases and when they have to be heard and otherwise. So there's a lot of what I guess would be technical procedural issues that are here that create problems where if in a normal case that you might have a civil type of case where you had basically as much time as you wanted to visit and talk about the issues and try to come to some resolution. In this particular case, with rate cases and timing, it's become a real issue, and one that's mutual to all of us. I'm not pointing out that anybody's created problems. With me, and I'd like to, then I'll turn to my opening. With me is Mike Parnell, Executive Director of Missouri School Boards. Mike's been here for a long, long time. And Louis Irwin Sr. and Louis Irwin II. I know Louis Irwin Sr. and I worked on the legislative when this statute, a unique statute I'm going to address, was passed in 2002. I think some of the commissioners may have been in the House during that time it passed. You all would remember if you were. The Missouri School Boards Association is a 501c3 or C6 trade association. We represent about 390 elementary and secondary school districts with about 2,650 school accounts that utilize natural gas off of whether they're Spire, almost all the different gas pipelines are, of course, subject to the statute. They don't get to, the gas companies don't get to opt out. It's a mandatory statute that should rule equally for everyone. Under that statute, the schools have organized a purchasing cooperative called MOPERC, which is really a school board natural gas consortium. We purchase gas through agents, through gas on the interstate pipelines and from sources outstate. It's typically transported in on the interstate pipeline system. It's passed off to the local utilities at I guess the word then would be city gate. And then we utilize the distribution system, the local distribution system of the local utility to pass the gas to the schools. The statute, again, was created in 2002. It was House Bill 1402, and it's been codified and changed once, I think, the next year or so, but it's now Section 393-310. If I had to say there's one thing that's significant and unique about this case, is the fact that statute exists. No large industrials have it. No other, the pipelines, no interstate pipelines have it. It is unique to the schools, and it has some language that's binding. Whether it's always been followed is an issue that the judge and you all will have to ponder, but the fact of it is Missouri law in a statutory format. It creates an aggregate supply and transportation program for all eligible schools, requires the gas corporations to file tariffs for year one, which I believe was 2003, as well as thereafter. Those tariffs were required, and again, this is statutory language, required a minimum to allow the purchasing of the natural gas supply and transportation through this consortium. The resale, and now listen, the resale and transport service of a gas corporation must be at the cost plus the transportation fee. That is a critical statement. You'll hear it this morning. You'll see it in briefs, and it's important in any later discussions as to exactly the meaning of that. The statute also allows for the inclusion in those tariffs of all applicable distribution costs, plus an aggregation and balancing fee determined by the commission. It's not to exceed 0.4 of 1 cent per therm delivered the first year. There's no telemetry required for the schools and no special metering unless the school uses, I believe, 100,000 therms per year. The tariffs must have no negative impact, financial impact on the gas corporation, on other customers, or which I think the statute uses taxing entities, which I believe is really the cities and the counties. Pipeline capacity is to be treated in the large, like the large industrials. That is the physical treatment of the gas and how it's shipped, how it's delivered, how it's charged is handled that way. So there's really no unique circumstance for that. But again, that's the physical handling, not the costs. And that was actually added a year or so afterwards in the statute. Excuse me. Interestingly, immediately after the statute was passed in '02, there were 7 gas dockets created. The one that's applicable to Empire was Aquila, which was their previous name. It's case number GT2003-0038. I'm going to, at one point, ask the commission, under their rules of evidence, that the commission administrative note the report and order in that case, as well as any other matters in that file, and I'll be passing out a copy of the report and order at the conclusion of my statement. There was an order in approving the stipulation agreement on August 15th, 2002. It kind of reviewed the history of the statute. It recognized there would be model tariff sheets that would have no material change. And that's, again, another important word. No material change in the revenue requirements of the companies. And the company would report its actual incremental costs each year to the commission so they could compute the over and under recovery of the costs. The commission, in their order, recognized there might be small changes in revenue and financial impact, but again, because of the schools were at a smaller volumeric numbers, that the commission held would not be material unless otherwise shown. No party was allowed to have any unreasonable delays, paragraph 8. And the companies were also required to provide yearly data, including the administrative costs, which are the incremental costs and the gas costs, as well as gas costs, including distribution costs and aggregation and balancing fees. I think, as Jim mentioned, I'd say the gravamen of this case really is 2 things. It's the issue of cash out and carryover, which I know my witnesses have addressed in really, of all the years we've been involved in this, this is the best presentation I can recall where it's really historically been explained what has gone on in this case from the inception to where we are now. It's really a treatise on the gas transportation program in Missouri. And that includes, I think, our witnesses, the company witnesses, as well as the staff witness. It's really I'm reluctant to use the word good job, but it's very complete and understandable. Again, the issues in this case are carryover and cash out, and again, the separate tariff. I think we've used a separate tariff. I'll deal with that issue in a number of cases. It really does make sense because this is such a unique circumstance with a unique statute. The separate tariff, to me, is the clearest way to deal with it, to deal with even adjustments we might make. If you've got a separate tariff, it accommodates that. We think the current Empire position is flawed. There's been no cost support for the present filing on aggregation and balancing. There's been really no cost support on even the cash out. And the cash out, the earlier case that was talked about, has created a cash out that is for imbalances that really is applicable to large pipelines and industrials. And it creates a circumstance where if the schools are short, we're paying up to 150% penalty. And if the company is in error, we only get a 50% recommendation. So we think per se that current cash out and any other cash out that models after that sliding scale, again, is contrary to the statute in that it is beyond the actual costs. The rates that for the daily computation are included. They're a public record. They're easy in documents, which are referred to, I think, in the actual company statute. It's either natural gas weekly or gas daily. Those are like publications that give the the pricing for gas. It's a daily evidence and with monthly summaries. And I guess in conclusion, if there is one here, we're talking about a statute in 2002, and we are here 20 years later, still with an unresolved situation on the actual cost of the gas to these companies. This matter has been kicked down the road. The last time this was set, these rates that were mentioned, I think in Jim's statement, in that case, the school board didn't participate in that case. We didn't even receive notice from the commission that it was going on. And I could say that might be my fault, but the notification system then was not like EFS today. In any event, at that case, when these were set, we weren't there. As to waiting for the next general rate case, maybe that's not a choice. And being very candid about that, we would, again, we're buoyed to hear the company talk about they're willing to meet with us. We'd like, if we could, as I said, if we could order pizza and start the meeting today at 1, we'd like to do that. But in any event, I appreciate your attention. I appreciate Commissioner Holtzman being here. I know he was, I think, in the school system at one time, so we know this is dear to his heart. And other than that, again, I'm going to, at the point, I think, if we introduce the testimony, which we believe, I think in my series of 300 through 300, I'm going to mark that one report and order as one of the exhibits. And again, note that the staff witness, and we mentioned, our witnesses mentioned several other cases which might be referred to by the parties in briefs or otherwise. So with that, I'm going to, I'll close and stand for any questions. I know this is the procedure in this is not quite like a civil trial, but if there's anything I could add at this point as a non-evidentiary comment, I'd be happy to do that.
Right, Mr. Brownlee, thank you. I will call staff counsel, Ms. Myers, up, and then just while you're changing, if I hear anything from Commissioner, you can come back and answer questions, and otherwise, we'll just move on to staff.
You bet. Thank you.
Thank you so much. Ms. Myers, when you're ready.
Well, good morning, and may it please the Commission. My name is Jamie Myers. I am here representing the staff of the Missouri Public Service Commission. Staff witness Keenan Patterson has sponsored and pre-filed rebuttal and surrebuttal testimonies addressing the issues remaining in this case. Mr. Patterson is here today to answer any questions on this testimony, but just briefly, I would like to give an overview of staff's position. First, staff recommends the Commission deny MSBA's request to modify Empire's aggregation, balancing, and cash-out charges in this case. Staff's own analysis indicates that Empire's aggregation and balancing costs have likely increased since the development of Empire's current fees from the prior rate case, but staff is not proposing an increase in these fees. Instead, staff recommends the Commission approve Empire's proposal to allow the current fees to remain unchanged. Empire's current fee for aggregation and balancing services for small transportation customers was developed from many rounds of testimony, as Mr. Fisher mentioned in case number GR-2021-0320. As staff witness Patterson states in his rebuttal testimony, the current fees are based on the record developed in that case and can be presumed just and reasonable. Further, despite MSBA's many claims that these fees are not based on cost, MSBA has not presented reliable evidence on what Empire's actual cost of providing aggregation and balancing services to small and medium transportation customer is, nor has MSBA provided reliable evidence supporting what an appropriate cost-based rate should be. Instead, MSBA advocates that the Commission either entirely eliminate these fees or greatly reduce them. Regarding cash-outs are a common and reasonable practice for resolving imbalances for both gas corporations and interstate pipelines. Further, the application of multipliers to cash-out prices is another practice of gas corporations and interstate pipelines that provide an economic signal to encourage shippers to closely balance gas delivered and received. The specific multipliers currently used by Empire are consistent with those that are charged by upstream pipelines. Staff recommends the Commission approve Empire's proposal to maintain its current cash-out practices. Lastly, staff recommends the Commission deny MSBA's request for a separate school aggregation tariff at this time. A separate tariff is not required by law, nor is it practically necessary to implement a school aggregation program. School aggregation pools are fundamentally transportation customers, and Empire's current transportation tariff has been able to adequately address the unique statutory requirements for school aggregation pools. Now, as Mr. Fisher stated, as Empire is willing to meet with staff and MSBA and other stakeholders to look for a standalone transportation tariff in the future, staff is more than happy to be part of that conversation, and in fact has been part of that conversation. But again, at this point in time, the complexity of doing that, it would be premature to try to do that in this case. Staff witness Keenan Patterson, again, has sponsored pre-filed rebuttal and surrebuttal testimonies on staff's recommendations that I just mentioned. Mr. Patterson is here today to answer questions on this topic, and I am here as well if you have any questions for me. Thank you.
Ms. Myers, thank you so much. And we'll see if we have any opening statement from Public Counsel. Mr. Williams?
Just briefly, thank you.
When you're ready, sir.
Good morning. Nathan Williams, appearing on behalf of the Office of the Public Counsel. May it please the Commission. Public Counsel has no witnesses on any of these particular issues in this case. Public Counsel's primary concern is the potential and almost certainty of cross-subsidization due to imbalances. Public Counsel understands that imbalances are measured monthly, whereas spot market gas is done instantaneously, which creates the potential for imbalances, and that's really staff's concern with these transportation tariffs or school aggregation. It does not have an issue with schools aggregating to purchase natural gas, but it does have a concern with the right prices going to those schools. And that's it.
Right, Mr. Williams, thank you. Any opening on behalf of MECG?
No opening for MECG. Thank you.
Mr. Opitz, thank you. And Symmetry has been excused from this hearing. All right. Anything else before we proceed to cross-examination? I believe the first witness is going to be Empire's witness, Ms. Earhart. Anything else? Okay. I don't know if Ms. Earhart's in the hearing room or on WebEx.
Yes, she is here. I would call Tashiana Earhart to the stand.
All right. If you'll come forward to be sworn, please. All right. Good morning. If you'll raise your right hand to be sworn, please. Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, thank you very much. And if you can try to speak into the microphone more for people who are participating by WebEx. And Mr. Fisher, when you're ready.
Thank you, Judge. Please state your name and address for the record.
My name is Tashiana Earhart. My business address is 602 South Joplin, Joplin, Missouri, 64802.
Are you the same Tashiana Earhart that filed rebuttal testimony and surrebuttal testimony in this case?
Yes.
For purposes of the record, I would like to have the rebuttal testimony of Tashiana Earhart marked as Exhibit Number 1 and the surrebuttal as marked as Number 2. Do you have any changes or corrections that you need to make to either of those pieces of testimony?
I do. I need to make one correction and then one change. On my rebuttal testimony on page 6, starting on line 6, I answered to Mr. Irvin's question regarding EDG's requirement that schools with loads of over 40,000 CCFs have telemetry. I answered that incorrectly. I need to fix that to say that all transportation customers, with the exception of individual schools participating pursuant to Section 393.310 RSMO, are required to install telemetry at the customer facility individual schools participating pursuant to Section 393.310 with annual gas consumption greater than 100,000 CCF are required to install telemetry.
And would that replace the answer that you have currently on page 6, lines 6 through 8?
Correct.
Okay. And do you have another change or correction you need to make?
Yes, referring to your opening statement that we're going to withdraw the issue 1C. So in my rebuttal on page 3, line 5, we'd like to remove that question and answer.
With those changes, if I ask you the questions contained in Exhibits 1 and 2, would your answers be the same?
Yes,
And are they true and correct to the best of your knowledge and belief?
yes.
Your Honor, I would then move for the admission of Exhibits number 1 and 2 and tender the witness for cross-examination.
Mr. Fisher, thank you. Exhibits 1 and 2 have been offered. Any objections? Hearing none, Exhibits 1 and 2 are admitted into evidence. We will move to cross-examination. Staff, any questions?
No questions, Judge.
All right, thank you. Public counsel?
No questions, thank you.
Thank you. MACG?
No, thank you, Judge.
MSBA?
Yes. Good morning. I'm Richard Brownlee, representing Missouri School Boards. I think we've met earlier today, and I know your company well, and Jim. When were you first employed with Empire? And I'm going to use, well, let me ask you, are you also employed by Mid-States and Liberty and Empire?
I started with Empire District Electric Company back in December of 2008. I worked for the electric side up until 2013.
Yeah.
And then I came over to the Empire District Gas side in 2016. And I'm currently in a position of manager of gas supply for Central, which includes both Mid-States and Empire District Gas.
So I take it you were not employed by either one of those at the year 2002 when the statute was passed?
Correct.
Were you employed by any gas utility during that period? That is, prior to what I'd say this hearing or this issue, were you familiar with the Missouri School Board's statute, which I'll refer to?
Prior to 2008?
Yes.
No.
Okay. And you testified, I believe, the company generally supports staff's position on aggregation and balancing. Is that a fair statement?
Staff's position? Yes.
Okay. And if staff's position on balancing, aggregation, or cash out proved to not be at cost, would you then support the staff position?
Well, the rates that are in the tariff right now, they were analyzed to be at cost.
Okay. Do you know whether they, in fact, are at cost on this case? Now, I know they were set much before this case, correct?
Correct.
Yeah. But I'm talking about this case. Did the company do any analysis on the cash out costs for this case?
No, the rates that are in the tariff today were reviewed in the prior rate case.
Okay, no, but again, I understand that. I'm asking about this case today. Did the company provide any cost data to support the rates in this case that you're asking the commission to approve on cash out?
We didn't change those rates.
Right.
The rates were reviewed back in the prior case.
So answer is no, you didn't provide any additional data in this case?
No.
Okay. And the same for aggregation. Did you provide any cost analysis for this case on the aggregation portion of the issues before us?
No.
And the same question for distribution costs. Did you prepare any cost data for this case on that issue?
No. All analysis was done in the prior case.
Okay. And are you aware that the paragraph 4 of that statute says that the natural gas company shall apply gas corporation costs of purchasing of such gas supplies and transportation. You know that's in the statute, correct?
The statute says that it requires the commission to establish the charges.
Okay, but if you didn't supply any additional data, then the commission has nothing from you, and I don't know if it's staff, I can ask them the same question. Did you, but you didn't supply any additional costs for this case, did you?
No specific
Okay.
data for this.
And do you know of any other rate case? We've heard that the school boards didn't supply any cost data. Is it the obligation of the school boards to supply cost data for cash out or aggregation or balancing?
We supplied the data to them through the data request. They have the bills and all the cash out materials.
Well, why didn't you do it if it was that easy? And by you, I mean the company.
It was not required for this rate case.
Okay. Well, do you know that the statute says here that the company is supposed to provide data on the existing case, on their costs? Even though that was 20 years ago, the statute still is exactly the same it was then.
Your Honor, I would object to that question. I think it's a mischaracterization of the statute. It also calls for a legal conclusion.
Okay.
Yeah, I'll sustain.
Okay, thank you.
Who's objecting?
Jim Fisher?
I'm sorry, that was Jim Fisher. I'll try to identify myself. Sorry.
Thank you.
I'm sorry, Mr. Brownlee, when you're ready, sir.
Yep, I'm sorry. On the rebuttal testimony, you said you did not agree with, and it's on page 6. Do you have that in front of you, Tash? Page 6, lines 9 through 12. And I think also you mentioned you didn't agree with page 14, lines 22 and 23. I'm not going to approach the witness, but because she's got her testimony. Let's go to page 6, lines 9 through 12. You have that?
Regarding the capacity release?
Yes.
Yes.
Yeah. And you mentioned, are there any large volume MSMBA schools on your utility system that would be classified as large volume otherwise?
Not to my knowledge. I don't believe, we do have a couple of colleges, but I don't think those are MSBA.
Does your company release capacity to small volume schools?
Yes.
Does the statute state that a company must provide for transportation to service to the Missouri schools on the system?
Objection again, a legal conclusion is being called for.
Well, I asked her if the statute states it. That's not her opinion. She can say if the statute states it, Your Honor, it says what it says.
Yeah, I'll overrule. She can answer if she knows, and if she doesn't, she
You
can
want
say
me to
she
read it
doesn't know.
again?
Yes.
Yeah. Does the statute state that the company must provide for transportation service to the eligible schools?
Yes.
Yeah. And do you know what year it was? I think Mr. Fisher may have mentioned, do you know what the last time that the commission actually changed the aggregation and balancing and cash out charges? Do you know what year that was?
The rates became effective 2010.
It was, would you accept that I believe it was GR 2009-0434?
Yes.
I think that's correct. I don't mean to mislead you. That wasn't any tricky question. Without the cost report we've talked about, how does the commission make any finding on that in this case?
On the costs that were established?
For balancing, aggregation, or cash out? How do they do it if there's no data from the company on that issue?
I'm not sure. I'm not sure what was provided in the previous rate case since I wasn't involved. I'm not sure what witnesses they used for that rate case. However, I do know that our pipeline costs have only increased since 2010,
Right.
which means those costs have not gone down. they've only gone up.
But those costs that you just talked about, the increasing costs, wouldn't that be normally something you'd put in your rate case?
Potentially.
Okay. So if public counsel would like to know what those increased costs were, just so we'd wonder about cross-subsidization, but the company hasn't produced that, have they?
No.
Okay. Excuse me a minute here. Do you know personally, and I know it's from an earlier case, do you have any knowledge about the aggregation and balancing charges that are currently in your tariff and how they might compare to other utilities? In your preparation, did you review that?
No, I'm not familiar.
So you couldn't answer any questions about that in terms of the actual dollar amounts compared to other utilities?
No.
Okay. Do you know, would you accept that the aggregation and balancing charges are 5 times higher than your sister company, Liberty Utilities?
I'm not familiar with all the other utilities' cost structures. I recently took over Mid-States, so I'm still learning Mid-States cost structures.
Well, I'm not to embarrass you, but I mean, you didn't compare for preparation today, like what these fees, what these rates are compared to your sister company that the Missouri schools pay. You don't know whether there's a 5 times disparity between your company, Empire, and Liberty.
Which component?
Just the rates in general for the aggregation and balancing charges. They're 5 times higher than your sister company. Are you familiar with that?
The aggregation charge is the same.
Yeah. And balancing. Do you say they're the same?
The aggregation,
Yeah. They're not 5 times higher than, that's your test?
not to my knowledge,
Okay, all right.
but I'm not as familiar with that tariff.
Well, if you're not familiar, then you just don't know. Is that a fair statement?
Yes.
Okay. Could we have just a minute? Just take one second.
Certainly.
Excuse me, right on just that very last question. To be fair to you, if you combine the current aggregation and balancing fees of Empire, are you aware that they're 5 times higher from the Missouri schools than Liberty's charges? Are you familiar with that?
No.
Okay, all right. I think that's all at this time. Thanks so much, appreciate it.
All right, thank you. Let me see if we have any bench questions. I will have a few questions for the witness. Commissioner Holzman, any questions? Okay, I don't hear
No,
any.
Judge, no questions at this time.
All right, Commissioner, thank you. Any other commissioners that have any questions? All right, Ms. Earhart, I'm going to have a few questions for you. If I could direct you to page 3 of your rebuttal testimony, and more specifically like the bottom of page 3, top of page 4, when you're discussing balancing approaches. Can you explain, I guess, in more detail what is Empire's concern with other balancing approaches that create opportunities for participants to the detriment of Empire's firm sales customers?
The carryover or netting. There's a couple of areas of concern for the company. The first one is the company has limited resources to use to balance the company's city gates. As Patterson pointed out in his rebuttal testimony, the line packs, other utilities may be utilizing line pack. To my knowledge, Empire does not utilize the line pack, so that doesn't give us the additional flexibility. Another one is we do not have any on-system storage. so we can't pull from multiple storage scenarios. Also, the storage that we use to serve the firm sales customers is limited. We don't have an abundant amount of storage for the system. So any capacity that is being held for the firm sales customers, it's crucial that we keep the majority of that capacity for those firm sales customers. The firm sales customers pay for that storage capacity 365 days a year at a higher cost. With netting and carrying over, I think that there could be an opportunity for unintentional scenario that would potentially harm the firm sales customers. And for example, if it was November and we're heading into winter and the prices are increasing, there may be some incentive to go long, which leaves more in storage for the colder months when the prices are higher, which means that short-term storage would be taking up the capacity that's meant for those firm customers. And then maybe towards the end of winter, like if it was February and it's very cold, then there may be incentive to go short in February, meaning you're withdrawing more of the storage out that was meant for the firm sales customers and being replaced later by the customer or the transportation customers in the lower priced months.
Okay. And I have a few questions, and if you've already answered them, please let me know. I may miss some of your answers as it applies to all these questions, but can you explain in more detail how Empire's pipeline storage contracted for firm sales customers would be used by aggregators if netting or carryover of imbalances were used?
If you use the netting, if they carry over a balance, so if they're long or they're short, they've either used storage. We have a storage withdrawal plan, and we're trying to use a certain amount of storage each month. And if it's unintentionally used during a different month, then we have to make adjustments. With the netting and carrying over, I think it's just that's an asset that the firm sales customers are paying for 365 days a year. And this is the solution that they're proposing is like a short-term storage solution minus the cost, but it's taking away that protection that's meant for the firm sales customers.
Okay. If I can direct you to more page 4 of your rebuttal testimony, can you explain in more detail how aggregation and balancing fees reduce gas commodity fees charged to your customers through the purchase gas adjustment clause?
The aggregation and balancing fees that we collect from the different transportation pools are directly credited to our PGA mechanism. So whatever the total gas cost is for the year, we take those revenues and reduce our gas cost, which goes back to the firm sales customers.
Okay. What does Empire do to balance the small volume pools?
Each day, when gas is sent to the gate, if there is too much gas sent to each gate, which would be a combination of your large volume, small volume, and sales customers, whatever the excess is, our no-notice storage will take care of that. Or on days where there's too little gas sent to the gate, the storage will balance all of the city gates.
How did Empire balance these small volume pools during Winter Storm Uri?
When you say how, do you mean how much or?
I guess your method. I mean, how much is fine as well, but more your method.
The method? We have a regression model that predicts how much our system should use and how much we should withdraw. And any of the additional shortage from the small volume pools gets balanced from the storage.
Were there issues with those imbalances of the small volume pool customers that impacted Empire's distribution system as a whole?
Yes.
What were those issues?
During the storm, the school pools did not send enough gas during the storm for reasonable expectation of usage.
Does Empire have the ability to read school gas meters without telemetry?
The equipment that we installed has the capability to produce daily reads, from what I understand. It wouldn't be on a real-time basis, but at the end of the month, it would be able to give daily data, from what I understand.
Okay. Do you have a copy of Mr. Irvin Sr.'s corrected rebuttal testimony?
I do.
Okay. If I could direct you to Appendix 4 of that testimony,
Okay.
and let me know when you're there.
Sir rebuttal?
Correct.
And I'm sorry, one more time, Appendix
4.
4?
Yes. And specifically, Empire's response to data request 7.2.
Seven 7.2. Yes.
Okay. Do you know who James Young is, the respondent to that data request?
Yes.
I think the data request asked if Empire buys pipeline storage for transportation customers, and Mr. Young said no, but explained that Empire uses upstream storage services. Is that correct?
Let me read the response.
Sure.
Please. Would you like my interpretation?
Well, I guess I had a question, and you can also give your interpretation if you want. Would the daily balancing for service provided to the city gates include all gas, including transportation customers?
Will you repeat that?
Sure. Would the daily balancing for service provided to the system city gates include all gas delivered to Empire, including the transportation customers?
Correct. It would
Okay.
balance everything at the end of the day.
Okay, great. Why is an analysis on the impact to firm customers important before making any tariff change to aggregation and balancing fees?
An analysis of the storage and aggregation fees for the benefit of the firm sales customers. You would want to make sure that their costs are being recovered, that they're not paying for storage or transportation costs that other customers are using.
Okay. Could you tell me why it takes time to develop and implement changes to the STP tariff?
Currently, Empire does not have a school tariff, a standalone school tariff. We have transportation tariffs that have flexibility that will allow the schools to still participate in a transportation program. Our sister company does have a standalone tariff, which we had talked about trying to model something along those lines. However, that tariff needs to have major, just some updates and language improvements. That's going to take some time.
Okay. I think those are all the questions I have. Thank you. Let me see if we have any recross based on bench questions. And I'll begin with staff. Any questions?
No questions, Judge. Thank you.
Thank you. OPC?
Thank you, no.
MECG?
No, thank you.
MSBA?
Excuse me, I've still one little thing. Regarding sort of the overall issue here, the carryover, the tariffs, the special tariffs, and your company, along with the school board and with staff, were you around or were you present and during 2018 when the company proposed a tariff change on these issues and with some meetings that occurred?
I was in the gas supply department in 2018.
Did you attend those meetings, any of them at all, or not?
Are these the meetings with Jill Schwartz?
Yeah, I think, yes, yeah.
I did attend the meetings.
Okay, what were the purpose of those meetings? Do you recall?
I was not the main lead on that meeting.
Do you know if the commission, or if the company had filed some actual tariffs to address a number of these issues at that time?
For Empire, not to my knowledge.
You don't know that?
No.
could they have? I mean, if you just don't know yourself whether proposed tariffs were filed at 2018 to address these issues.
Not to my knowledge.
Okay, and do you know whatever happened to that filing?
No.
Okay, all right. Thanks so much.
Mr. Brownlee, thank you. Any redirect, Mr. Fisher?
Just briefly, Your Honor. Judge Pridgeon asked you, I think, how aggregation fees were treated related to the PGA. Do you recall those questions?
Yes.
Is it correct to conclude that aggregation fees don't help the company's bottom line? They get flowed back to help firm customers?
Correct. None of those dollars are flowing into the revenue for the company. They all go directly back to the firm sales customers to reduce their cost.
So by raising those aggregation fees, it wouldn't help the company's rate of return on equity or rate of return on investment, right?
No.
Did Empire District Gas Company request the approval of any increases in aggregation, balancing, or cash-out fees in this case?
No.
Are you aware that some rates are going up as a result of the stipulation and agreement among the parties on other firm customers?
Yes.
You were asked a question by Mr. Brownlee about paragraph 4 of a statute, and that statute happens to be attached to Louis Irwin's II direct testimony. Do you have a copy of Mr. Irwin's direct testimony? And I'd like to refer you to that statute that he includes on Appendix 1. Do you have that now?
Yes.
I'd like to refer you to Section 393, 310, and he asked you about paragraph 4. That paragraph states, "The tariffs required pursuant to subsection 3 of this section shall at a minimum," and then I'd like to drop down to subsection 2 there, where it says, "provide for the resale of such natural gas supplies, including related transportation costs to the eligible school entities at the gas corporation's cost of purchasing of gas supplies and transportation, plus all applicable distribution costs." Is that what that says?
Yes.
So that says that that portion has to be at cost. Is that how you would read that?
Correct.
Let's go on, though. It says, plus an aggregation and balancing fee to be determined by the commission. Is that right? Is that what the statute says?
Correct.
Does that say to be determined at cost by the commission?
No.
Has the commission determined the appropriate aggregation, balancing, and cash-out fees for Empire District Gas in a past rate case?
Yes.
That's all the questions I have, Judge. Thank you.
All right, Mr. Fisher, thank you. Ms. Earhart, thank you very much. You may step down. And I believe the next witness is going to be MSBA's witness, Mr. Irvin Sr., is that correct?
I think we could have Junior, I think he has more detail, and then I think it'd probably be simpler.
Get Ms. Earhart's spelling of her name real quick.
I'm sorry.
Yeah.
We would prefer to have Irwin Junior be first, if it would. I think then it would allow, if there's any follow-ups or historical questions, Senior would be more in a position to answer those.
Okay, sounds like MSB wants to call Mr. Irvin II. Any objections or anything further before he takes the stand?
Judge, I think the court reporter was asking for the spelling of the witness's name.
I'm sorry, yeah, it's Ervin is the last name.
No, the prior witness.
Oh, excuse me?
Ms. Earhart.
Ms. Earhart, Earhart.
And her first name, T.
Tashiana, Tatiana.
Great, thank you so much.
Thank you.
Ukraine.
Okay, anything further before Mr. Irvin II takes the stand? All right, if you'll come forward to be sworn, please, sir. If you'll raise your right hand to be sworn, please. Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Thank you very much. You may have a seat. And Mr. Brownlee, when you're ready, sir.
Thank you. Would you please state your name for the record?
Louis Irvin II.
By whom are you employed?
I'm with LEV Energy Advisors, appearing on behalf of Missouri School Boards Association.
And has your company represented the Missouri School Board Association for a number of years?
Yes, prior to me joining the company, Louis Sr. Represented them since the beginning of 2002, I believe.
You have uniquely the same name. Is he your father?
Yes, he is.
Okay. You have filed testimony in this proceeding, is that not correct?
That's correct.
And I think under the previous procedural requirements from the judge here, I believe we've marked your direct testimony as Exhibit 300, and I believe we have marked your rebuttal testimony as 301. Is that correct?
If you say so.
That's the two sets of testimony you filed?
That's correct.
And if I ask you regarding 300, if there are any additions or corrections that you'd like to make on that set of testimony as Exhibit 300?
No, there is not.
And if your answers, if you were asked the same question, and would your answers be the same?
Yes, they would.
And again, for Exhibit 301, have you filed that testimony?
Yes.
And is that your rebuttal testimony?
Yes, it is.
And again, if we ask you the same questions, would your answers be the same?
Yes, they would.
Are there any additions or corrections?
No, there are not.
Okay. And Your Honor, at this time, I'd also like to have the commission take administrative notice, and I think mark it probably as Exhibit 303, and that's the order approving the stipulation and agreement in the case number GT-2003-0038, which was the original Aquila case that I believe is a predecessor to Empire. And that was the case, one of the 7 that was issued by the commission at the immediate conclusion of the statute in the year. And at this time, I'm going to pass out copies of that report in order. I hope I've got enough copies, so. And that again, I believe would be Exhibit 303.
I don't, but I'll get one. Okay.
At this time, Your Honor, I'm going to go ahead and offer Exhibits 300, 301, and 303, and also make note that there are a number of other PSC decisions mentioned in various testimonies, and I believe under the evidentiary rules contained at 4 CSR, whatever the evidentiary rule is for the commission, that there is a specific paragraph that deals with prior commission records, public records, and this would be one along with the other ones. And I'd ask that the commission would be able to take administrative notice of those records in any subsequent documents or briefs that might be filed. And I will tender Mr. Irwin II for cross.
Very good, thank you. Exhibits 300, 301, and 303 have all been offered. Any objections? All right, hearing none, Exhibits 300, 301, and 303 are admitted. See if we have any cross-examination. MECG, any cross? Public counsel?
No questions, thank you.
Questions from staff?
No questions, Judge.
Empire District Gas?
Good morning, Mr. Irwin. I have just a few questions for you. I'd like to direct you to your direct testimony on page 4. At lines 15 and 16. There you indicate that MSBA is the authorized purchasing agent for approximately 2,390 STP accounts. What does the STP account mean?
School Transportation Program.
Of which 140 are in the Empire Service area. Is that correct?
That's correct, what I stated, and that's, to the best of my knowledge, that's correct.
Does that mean that the association serves 140 schools in the Empire Service area?
That's the way I read it, yes.
Okay, so would it be correct to conclude that the Empire Service area represents roughly 6%, if my calculator was right, of your total number of schools that you serve in Missouri?
To check your calculator, yes, sir.
Okay. On page 5 of your direct, line 20, you state that STP was created in July 2002 with the enactment of Section 393-310 RSMO. Is that right?
Yes, sir.
So has the school transportation program been operating in Empire Service area for about 20 years?
To the best of my knowledge, yes.
And then on page 5 of your direct, at line 15, you state, schools, students, teachers, and taxpayers benefit from group purchasing of natural gas. Absent these STP savings on gas supply costs, schools would have fewer dollars for teachers, computers, and other classroom learning tools. Is that right?
That's what I stated, yes.
Would it be correct to conclude that the Missouri schools have benefited as a result of the school transportation program provided by Empire District Gas and other LDCs?
Yes.
Would you characterize the school transportation program in Empire Service area as a success during those years?
Yes.
Then on page 9 of your direct testimony, at line 17, you state, MSBA would like to have the commission order STP tariffs to comply with Section 393-310 RSMO so that MSBA can avoid intervention in rate cases. Is that right?
Yes.
Is it correct that it's expensive for the association to intervene in natural rate cases?
Yes, it is.
Do you have an estimate of what the kind of costs you would avoid if you didn't have to intervene in rate cases?
I don't know that answer.
Okay. Mr. Irwin, would you agree with me that Empire's aggregation and balancing fees have been determined by and established by the commission in Empire's 2009 rate case?
That's what I have understood.
Okay. The statute does not mandate how the commission must establish the aggregation and balancing fees. Isn't that correct?
I don't believe that's correct.
Okay. Has the School Board Association ever filed a formal complaint against the Empire District Gas Company in the 20 years that the school transportation program's been operating?
Well, I haven't been around that whole time. We have definitely tried to work with every utility, including Empire, as stated in 2018 and 2019, and we're largely in agreement, and otherwise would have filed something that we had an agreement, other than staff just said that they would prefer it to be in a rate case. So, I think that's the extent of, that I'm aware of as
So,
far as a complaint.
to your knowledge, there's never been a formal complaint filed against Empire District?
I didn't testify to that one way or the other. I don't know the answer. Senior would be available to answer that question most likely.
All righty, that's fair, thank you. On page 6 of your direct testimony at line 16, you begin explaining the nomination process and how it affects cash outs and balancing. Is that right?
Yes.
Would you agree that if the aggregator or the transportation customer agent does a good job of nominating its expected customer loads, and with that assumption, then the cash outs and balancing penalties are really not a major factor for the customer or the pool administrator if he's doing a good job nominating them, right?
I don't know how you would define a good job, because most of them are not daily telemetry, so, the weather changes more than they can predict. So I don't know how to answer that.
Okay, well, isn't it true that it's when the aggregator or the transportation customer agent misses the mark for whatever reason, weather or anything else, on his nominations, that's when cash outs and balancing penalties become a concern?
Yes, I would say that every utility is that way and every customer is that way, yes.
Has MSBA estimated what would be the expected impact in dollars if the commission adopts your proposed aggregation and balancing fees in this case?
No, we have not.
You don't recall giving us an estimate of $1,800?
I don't recall the estimate. I do know we were not looking at total costs, because we were trying to make sure that we're looking at the principle of the statute, and because it sets precedent.
Sitting here today, what would be an estimate in your opinion?
I would have to check and look at volumes.
Okay. Do you think it would be less than $5,000?
I'm really not sure.
Okay.
It's not, we didn't bring the issue up as a dollar issue.
Let's turn to page 13 of your direct testimony. On line 4, where you state, making schools ultimately liable for actions or inactions of suppliers could effectively be used as a means to eliminate the MSBA program and force schools to be under Empire system supply, which typically results in the MSBA schools paying more for natural gas as compared to the current managed program. Do you see that?
Yes, sir.
At the time you filed your testimony, did you believe that Empire was attempting to eliminate the MSBA program in this case?
I didn't know their intent. What I saw was their red line tariff to remove aggregators and marketers from responsibility. So that, I'm not saying that was their intent.
Okay, do you believe that's their intent today?
I don't know their intent.
Do you believe that Empire is trying to force schools to be under the Empire system supply in this case?
I don't have any reason to think one way or the other, so I don't know.
Thank you for your patience. That's all the questions I have.
Mr. Fisher, thank you. Let me see if we have any bench questions. Commissioner Holzman, any questions, sir? Okay, I'm not hearing any, and I don't have any questions. So we don't have any bench questions, so no recross. And I believe this witness can step down. I'm sorry.
I had a question, if I could.
Okay, go ahead.
Mr. Fisher asked you about the size of the schools and the number of schools in their system compared to the overall. When you have penalty provisions like in the current tariff on the cash out, do schools have a way, to your knowledge, of adjusting any sort of income to schools to pay those kind of penalties, to pay those kind of charges?
I mean, they have, as far as I know, they don't adjust it based on those charges.
I mean, they don't get to raise their prices for their service schools provide.
I guess not. I'm not the expert on the.
Do you know whether schools get a huge percent of their revenue off taxes? I mean, if they get an unusual charge like a gas penalty, that can have a significant dereliction effect on schools, would it not?
Yeah, my comment was that these schools are not in control of that, and the weather is more in control even than the suppliers. And to penalize them 50%, either direction, either over-delivered or under-delivered, which benefits the PGA or takes some away from the PGA, that's out of their control. And so just the penalty is the issue, not the fact that there will be imbalances.
And regarding the questions you were asked about the costs of cash out and the cost of aggravation, is it the position of MSBA that you want to eliminate cash out in this case?
No, we really specifically said carryover would be the ideal way, but we also said that there's nothing wrong with cash out in principle and the methodology. It's just the fact that they're paying a 50% premium or a penalty if they have to buy more, or they're getting charged, or they're getting deducted 50% of the cost of gas. So that shows up up to 50% of the cost of gas. So that shows up directly on their bills as a big hit. So for example, if the cost of gas is $10, then they're going to have to pay $15. Now that's a high price, obviously, but we saw that at polar vortex Winter Storm Uri, and if they have to get money back from the company, they'd be getting it back at $5 for what they already paid $10 for. So that's the tiered cash out. The highest level would be 50%.
And really, isn't that the gravamen of the issue on cash out? Is just there's philosophically, it's not wrong if it charges the applicable costs.
Correct.
Yeah. And do you see? And we've used that word, the add-on. We've used the word penalty, haven't we? And that show up in the testimony. Is there any place in the underlying statute where you see any reference to a penalty in terms of the gas costs?
No, there's not.
And that gas cost is not from the transporter. The penalty is imposed by the utility, is it not?
That's correct.
Okay, thank you.
Right, Mr. Brownlee, thank you. And Mr. Irvin, you can step down, and I'm showing the time is just right around 10 o'clock, so this seems to be an appropriate time to take a mid-morning break. We'll take 15 minutes and resume at 10:15 with Mr. Irvin Sr.'s testimony. And I'll just remind everyone in the hearing room that WebEx is still streaming, so folks on the outside can still hear you if you're in the hearing room.
Jamie,
So
do you
anything,
have questions
anything
for
further?
Senior?
Anything further before we go off the record?
I can pass. I could pass him.
I'm sorry, go ahead,
Off
Mr.
the
Brownlee.
record.
Okay, we'll go off the record. We'll resume at 10:15. Thank you. We're off the record. We are on the record again in file number GR-2021-0320. Just as a bit of a roadmap where we've been, where we're going, we've had, we finished off with Mr. Irvin II, I believe, with his cross-examination. I understand Mr. Irvin Sr. is the next scheduled witness, and I think I heard on the, off the record rather, that no parties have any cross-examination for that witness. Is that correct? I'm hearing no response. I'm taking that as true. Okay, I'll have him take the stand. I will have a few questions for him, and then we'll go on to Mr. Patterson. As far as the presentation on the parties' stipulation and agreement, I'm unsure exactly how we'll proceed with that, but my gut reaction right now with commissioner response is that we'll just simply continue forward after Mr. Patterson's cross is done and take cross-examination, take the on-the-record comments on the stipulation and see if we have any bench questions on the stipulation. So I just wanted to give you a heads up. We'll probably just keep going after Mr. Patterson's cross is finished with the on-the-record presentation on the stip. So anything further before Mr. Irvin is sworn in? All right, if you'll raise your right hand to be sworn, please, sir. Do you swear the evidence you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You may have a seat. Mr. Brownlee, when you're ready, sir.
Thank you, sir. Please state your name for the record.
Louis R. Irvin,
Mr. Irvin, by whom you employed,
LEV Energy Advisors.
and have you caused testimony to be filed in this current proceeding?
Yes,
And have we previously asked and agreed the court reporter would mark your testimony as Exhibit 302?
yes.
Thank you. Very briefly, you've heard, and I know you're familiar with it, were you not the Louis Irwin that were representing the school board in the year 2002 when the statute that we've talked about was passed?
Yes, and before that, I think starting about 1998.
Okay. And during the proceeding of various cases dealing with transportation or the school issue, have you represented the school boards in front of not just this company, but I think most of all of the other gas utility cases that have occurred?
Yes, I was witness in all 7 utilities. Back at that point in time, in 2002, there were 7. Now there are 5, but I testified in each one of those.
Okay. And there's one case that we did not participate in, is that not correct?
Well, there was a case in 2009 that we didn't know about.
But we didn't therefore participate.
No.
Judge,
that-
I object. What procedure is going on here? Are we providing additional testimony?
No.
Yeah, I'm going to sustain. I mean, the point of this
Okay.
is he's already pre-filed testimony. He's here to stand cross, so
All right.
I'm going to sustain.
Okay. Well, I think you covered that in your testimony. If I ask you the same questions as indicated in Exhibit 302, would your answers be the same?
Yes,
And are there any corrections or additions you'd like to make at this time?
no,
Okay, at this time, Your Honor, I'm going to offer Exhibit 302 and tender Mr. Irwin for cross, which I believe you have questions, but I think other attorneys have waived.
All right, Mr. Brownlee, thank you. Exhibit 302 has been offered. Any objections? Hearing none, Exhibit 302 is admitted, and we'll just verify, does any counsel have cross-examination for this witness? Going once, going twice, very good. Commissioner Holzman, any questions? All right, hearing none, I have just a few questions for you, Mr. Irvin. If I could direct you to your rebuttal testimony, page 10. And specifically, like lines 11 through 13, please. And let me know when you're there, please.
I'm there.
Okay, thank you. I believe in that testimony you state that Section 393-310 RISMO requires gas corporations to provide services to small schools at incremental cost, and that rebuttal also includes Appendix 1, which is a copy of that statute. Is that correct?
Yes,
Can you show me where in Section 393-310 there's any reference to cash out and pipeline capacity releases?
Yes. As soon as I find it. Okay, let's see, we take it one at a time, I think. Okay. The reference to incremental cost is under paragraph 5.
Well, that's not quite my question. My question is where does it state any reference to cash out or pipeline capacity releases?
The reference to the cash out is under that paragraph 2, where it says the gas corporation's cost of purchasing gas supply and transportation. So I think I answered that.
Okay, okay. And if I could.
And then capacity.
Okay, all right.
And then the capacity, actually, the capacity part of the statute was not part of the 2002 statute. It came about a year later, and that is in paragraph 6.
Okay, thank you. If I could refer you to page 11 of your rebuttal, and specifically lines 12 and 13. And let me know when you're there, please.
I'm there.
Okay, thank you. I think in those lines you state under section 393-310, there will be neither negative impacts on others nor penalties to eligible small school entities. Can you show me where that language is in the statute?
It goes back to paragraph 2, where it says, at the gas corporation's cost of purchasing such gas supplies.
Okay. And then, and lastly, if I could refer you to page 13 of your testimony, lines 5 and 6, and if you can let me know when you're there, please.
I'm there.
Okay. I believe in that testimony you state staff did not represent school's interest in that case or comply with section 393-310. With that statement, are you referring to file number GR-2021-0320?
I believe that's correct, yes.
Okay, thank you. Those are all the questions that I have. Since we've had some bench questions, I'll ask if anybody has any cross based on my questions. No cross, very good. Any redirect?
Mr. Chairman, regarding the last question from the judge about that case, that was a case the school boards were not present in. Is that correct?
Correct.
Okay. And we did not receive notice at that time from the commission it was even filed.
No.
Okay. That was what I was trying to get at earlier. Sorry, I didn't.
No problem. Thank you.
Thank you. That's all I have. And again, I'm going to reoffer those exhibits, and that would conclude our position. If I can ask a question while I'm up here, did you rule on the admissibility of exhibit, the copy of the report and order from that case?
Yes, that's 303, and it was offered without objection and admitted. And thank you. 302 is admitted. Mr. Irvin, thank you very much. You may step down. And I believe that leaves us to Mr. Patterson. Anything further from council before Mr. Patterson is sworn? All right, if you'll come forward, sir, and be sworn. If you'll raise your right hand to be sworn, please. Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you, sir. You may have a seat. Ms. Myers, when you're ready.
Thank you. Mr. Patterson, please state your full name for the record.
My name is Keenan, K-E-E-N-A-N, Patterson, P-A-T-T-E-R-S-O-N.
Thank you. And Mr. Patterson, where are you employed and what is your job title?
I'm employed with the staff of the Missouri Public Service Commission. My title is Senior Professional Engineer.
And are you the same Keenan Patterson who prepared or caused to be prepared the rebuttal testimony that we are marking as Exhibit 100? And the sir rebuttal testimony that we are marking as Exhibit 101?
I am.
Do you have anything you wish to correct in either of those testimonies?
Yes, I have corrections to Schedules 4 and 5 of my rebuttal testimony.
All right. And those schedules are confidential, Mr. Patterson?
Yes.
Okay. Judge, we have provided the parties present here with copies of those corrections. Staff was going to offer those corrected schedules as Exhibit 102.
Okay, 102, and will that need to be 102 and then 102HC or some?
102C. And same with
Okay.
Mr. Mr. Keenan Patterson's rebuttal testimony. There will be 100 public and 100C. All right, Mr. Patterson, aside from those corrections to Schedules 4 and 5, if I asked you the same questions today, would your answers be the same?
Yes.
So the information in these documents is true and correct to the best of your knowledge and belief?
Yes.
All right, thank you. Your Honor, staff tenders Mr. Patterson for cross-examination, and we'll go ahead and offer Exhibits 100, 101, and 102.
Okay, and if you could, again, if I could get down in my notes, you'd let me know exactly what those exhibits are, please.
Sure. Exhibit 100 is the rebuttal testimony of Mr. Keenan Patterson, public and confidential versions. Exhibit 101 is the sir rebuttal testimony of Keenan Patterson.
Okay,
And Exhibit 102 is the corrected confidential schedules of Mr. Keenan Patterson, and this is Schedules 4 and 5 of Mr. Keenan Patterson's rebuttal testimony. And these are confidential in their entirety.
All right, Ms. Myers, thank you. Exhibits 100, 101, and 102 have been offered. Any objections? And those are admitted. That would be Exhibit 100, public and confidential, Exhibit 101, and Exhibit 102, confidential. Those are all admitted. Any cross-examination from public counsel?
No questions, thank you.
Thank you. MECG?
No, thank you, Judge.
Empire District Gas?
Just briefly, Judge.
When you're ready, Mr. Fisher.
Good morning, Mr. Patterson. I just have a couple of questions, or areas anyway. I think I'd like to begin by visiting with you about the staff's position on the proposal to eliminate cash-out balancing and substitute the carryover method. Are you familiar with those terms?
Yes.
Is the cash-out method used by other local distribution companies in Missouri?
Yes.
Would you characterize that as the predominant method used?
Yes.
To your knowledge, has it been used for a number of years since the school transportation program began?
Yes.
On page on page 4, beginning at line 15, I believe you explained to the commission why balancing is important. Is that right?
Let me look at my testimony.
Page 4, beginning at line 15.
Yes.
Would you explain how transportation imbalances could cause the sales customers' gas costs to be higher than they would otherwise have been if the costs had not been recovered from the transportation customer?
Well, any imbalance between the gas coming in or out of the utility system has to be managed somehow. So the utility would be applying its resources to those imbalances. Primarily, I would think in a smaller utility, either making withdrawals or injections to storage on an interstate pipeline, or potentially, depending on the severity of the imbalance, purchasing gas to make up for a shortage. And all those costs, at least initially, would tend to flow through the purchase gas adjustment because they are gas costs.
Would that mean, since it flows through the PGA, that it does not help or hurt the gas company's bottom line,
Correct.
but it could affect the impact on firm customers?
Yes.
Okay. I'd like to ask you to turn to page 9, line 2. There you calculate the average amount per school for some certain annual credits, is that right?
Let me review this briefly here.
Yes.
Yes.
You have included the numbers as confidential numbers, is that right?
Yes.
Judge, just for purposes of the record, Empire doesn't believe these average numbers need to be kept confidential if the commission would prefer to make them public. The table that he has in his testimony probably could be kept public or kept confidential, but the average numbers, we would not object if they were made public.
Okay, thank you.
On page 9 at line 2, you calculate the average amount per school for the annual credits, is that right?
Yes.
And that number, I'm going to go ahead and say it publicly, is $47 per school, right?
Yes.
And then on page 10 of your rebuttal, you discuss how much Empire charges the school aggregation pools on aggregation and balancing fees, is that right?
Yes.
You testify that the average annual charge is $154 per school per year for aggregation and balancing fees. Is that correct?
Yes.
So that's about $13 a month if my calculator works right?
Approximately.
Is it your understanding that Empire has been charging these fees since its last general rate case?
Yes.
I think that's all the questions I have. Thank you, Judge.
Mr. Fisher, thank you. Any cross from MSBA?
Good morning, sir. I'm Richard Brownlee. I think we've met previously and probably over the period of time in many years. I represent Missouri School Board Association, and I'd like to ask you some questions about your testimony and the issues in the case. I know you're very familiar. Just on a couple of things that Mr. Fisher had just asked while they're fresh in my mind. You said that the cash out was, I think, the predominant whatever called gas pricing methodology, that the cash out was predominant by the utilities in the state of Missouri. Is that correct?
Yes.
Now, does that include how many companies? Are you talking about 7? Well, there are fewer gas utilities now. What about Spire?
Spire cashes out everyone except the schools.
Right. Okay. So, and you all, basically, it's fair to say the staff is you prefer the the cash out method compared to the carryover method.
Yes.
That's right. And I think on several places in your testimony, you mentioned that the schools want to get rid of cash out. Is that your? Do you know that you've testified to that on several occasions?
I do believe I mentioned that in my testimony, yes.
Do you know whether they want to get rid of it or just make sure that Mr. Irwin Jr. testified that they want to cash out's okay as long as it involves just the cost. Isn't that a fair statement, is what he testified to?
My understanding is, his testimony is that they proposed moving to carry out balancing, and as an alternative, adjusting the multipliers related to cash out.
Yeah, so cash out could exist. It's their objection is the multipliers. Isn't that fair? That's a fair statement, isn't it?
I would say that is a reasonable statement.
Okay, well, I want to make sure that the commission understands that, because the school board, according to I read the testimony, is not against cash out, they're against the multipliers that are in effect. That's a fair statement, isn't it?
They are against the multipliers.
Yeah, okay. And regarding the issue, well, let me go back here a second here. Were you working at the commission, I know you were, in 2018 and 19?
Yes.
Were you familiar with that the company that Empire and the school boards came forward with a tariff at that time, dealing with these, I think, all of these issues?
They discussed tariff changes with staff and, I believe, EDG.
Do you know if they filed a tariff?
To my knowledge, they did not file a tariff.
Okay. And did you work and have meetings with them on that tariff, or on that proposed tariff draft?
Yes, I attended meetings related to that.
And what was the result of all of that? Do you know?
To my knowledge, nothing happened after those meetings. There was no tariff filing.
And is it fair to say that the staff opposed those tariff proposals from the company and the school board at that time?
I would say that the staff had issues with them.
Okay. Well, by issues, there wasn't supporting issues, was it?
That is correct.
Okay. And do you know whether, if it was withdrawn at that time, whether, since the 3 years has elapsed, whether the company or staff has worked on a subsequent tariff proposal dealing with cash out and balancing and aggregation?
Judge, I object. Mr. Patterson just testified he wasn't aware of a tariff filing.
Yeah,
Well, it's not a tariff filing. I said worked on tariff issues.
I'll overrule and let him answer if he knows the answer.
I'm not really that familiar with how much has gone on since then. I don't think staff has been very involved in discussions on that issue between then and this rate case.
Since the last rate case, when these rates were set, have you seen any further filings from the company on any of issues dealing with school transportation?
I'm not aware of any.
Okay. And you've worked on those cases, have you not? Of the Empire cases that have been filed since then?
Since 2009?
Yeah.
I'm not even sure if there has been a rate case since 2009.
Okay. And let me ask you, have you seen in this case any cost figures or supporting documentation filed by the company to continue the current charges for cash out? Anything the company has filed?
New since the last case, no.
Okay. Same question for aggregation and balancing. Any charges, any cost figures that the company has filed since the last rate case?
No.
Okay. And there are none in this case, are there? From the company?
Oh, I thought your last question meant since the last case. There were filings in the last case, but no new cost in this case.
Right.
So.
And so the only real figures have come from the staff that you testified to. Isn't that correct? Where you showed the chart I think you've got on that one page?
Yes.
Okay. Is that a normal procedure for the staff to file and do the accounting work for the company in a rate case?
Judge, I object. This is an unfair characterization of Mr. Patterson's testimony.
Yeah, I'll overrule.
I wasn't trying to say what the rate should be. I was simply trying to support the notion that there was cost basis for that rate in the previous case, and that it was a reasonable allocation of known costs.
Okay, but the charts you've put in your testimony is current in recent cases. It's not clear back to the last rate case, is it?
No, it represents current pipeline storage rates.
Right. Okay. Have you ever worked for a gas utility?
No,
Have you ever contracted for natural gas through any way for a gas utility?
no,
Okay. Do you follow the daily market price and the fluctuations in gas?
not in detail.
Okay. If it were proved that the cash out or carryover were contrary to the statute, would you be supportive of this, your position as staff?
I suppose if it were proved that it were contrary to law, it wouldn't matter what staff thought about it. That would rule.
Well, you're aware, are you not, that a statute could be on the books for a long time and not followed by the people who are supposed to follow a statute? Is that a fair statement?
That's fair.
Yeah. And do you know whether, in fact, since '02, this company has filed and always supported an actual cost figures to support their natural gas or their school tariff? Did you understand?
My presumption is that since the commission approved those rates, they were adequately supported in those cases.
And since that time, what'd you say, in '08? Or what? Trying to go-
Or since 2002.
Yeah. You don't know when's the last time the company filed any cost justification for cash out, balancing, or any of the factors that we've discussed today? When's the last time?
Well, there was evidence presented in the 2009 case related to the balancing fee.
Correct.
The aggregation fee has been the same since the beginning and has never had cost support from anyone.
Well, there's been no cost support from the company, this company for sure, right?
Right. And then the cash out multipliers are the same as those used by upstream pipelines. So those are the type of multipliers that the company pays for its imbalances.
With your knowledge, you are familiar with the statute, are you not?
Somewhat.
Well, you've reviewed it, I'm sure you have. You've filed extensive testimony surrounding the statute in the schools, correct?
Yes.
Do you know whether Spire has, since the time of 2002, filed any kind of annual updated documentation on any of the transportation cost issues?
Do you mean,
Have schools,
You mean
I mean, as
every-
Empire, I'm sorry, have they filed any annual updated reports on any of their costs since 2002?
I don't know.
None to your knowledge?
No. In terms of, are you referring to what the 2002 tariff stated about those filings? Yes, but those ended with at least the 2009 tariff, so that would have been the latest. And between then, 2002 and 2009, I don't know if any were filed.
And you don't know from 2009 to present when any have been filed?
Not to my knowledge, no.
Okay. Do you know whether the statute would require that filing?
Judge, I'll object. I think that's the legal conclusion.
I'll sustain.
Okay. When you have a gas company, this is a general question, when you have a gas company, do you know whether that statute would require that the school transportation issue be a part of every rate case that any gas company files?
I don't think it specifically says that.
And it clearly has not been a part of every case, as far as you know, from the gas companies you've worked on. Is that correct?
Correct. As far as I know, it's not been an issue in every case.
And you understand that the statute does require the gas corporation services will be at cost?
Yes, cost of service rate making applies really everywhere.
And then that says specifically gas and transportation, is that correct?
Yes, it does specifically say
Yeah.
gas purchase and transportation costs.
Do you see anywhere in the statutory language the approval or the mention of penalties for any of the services or any of the charges a utility could make to the schools?
Well, my understanding of the statute is that it allows the gas corporation to collect all the cost it has related to providing this service, and there are gas costs associated with paying penalties to upstream pipelines for imbalances.
But the penalties are provided by interstate pipelines. They're used there, correct?
Yes,
And large industrials, correct?
and all transportation customers at Empire District.
But none of those the other two groups I just mentioned none of them have a specific statute dealing with how they should be charged, correct?
Not to my knowledge.
Boy, I don't know. Could I just have a minute? I know excuse me for a second, maybe I'm fading here a moment. One final, do you know whether the company buys gas every day in order to supply to its customers, including the schools?
Well, I know they buy gas for every day.
Yeah.
I suspect they do end up buying gas every day because there are other types of purchases probably don't typically cover the full amount.
Okay, all right. Thank you, sir. Thank you.
All right, Mr. Brownlee, thank you. I have just a few questions for Mr. Patterson. We'll see if we have any recross or redirect. Mr. Patterson, if I could direct you to your rebuttal, and specifically on page 3, lines 2 through 4, and if you could let me know when you're there, please.
I'm there.
Okay, I believe in that testimony states Empire releases firm interstate pipeline capacity to its transportation customers or their aggregators, and those customers or aggregators control the use of that capacity. Is that correct?
Yes.
Is this capacity release identified on an interstate pipeline's electronic bulletin board that any pipeline customer can acquire, or is this something different?
My understanding is that it's something different, that it's specifically set aside for them in the tariff.
Okay. Can I direct you to page 5, line 18, also your rebuttal, and if you'll let me know when you're there, please.
Yes.
I believe on line 18 of page 5, you describe Spire, Missouri's requirements that school aggregation pools be balanced by adjusting nominations. Can you describe how nominations of gas for delivery are made?
Well, it's a little different for the transportation customer because they generally also have to give some kind of notice to the utility about their nominations, though I think in the case of Empire, Empire actually monitors that through the pipelines bulletin boards. But there is a schedule of processes for nominating gas. Generally speaking, most gas is nominated the day before the gas day on which it's to flow. There are later periods when they're able to make nominations or adjust nominations even during the gas day. But they would post their nomination with the pipeline. There would be a process of confirmation, communication back and forth between the pipeline and the shipper, confirming the information, and then kind of a reconciliation process where the pipeline would decide how much gas is actually going to flow and how much of that will be allocated to each of the shippers.
Okay, thank you. Can I direct you to page 8 of your rebuttal? I'm sorry, I don't have a line number, but I'm looking for, I guess, the area where you quote from Spire, Missouri's rate case GR-2021-0108, the testimony that cash-out balancing of school aggregation pools is desirable. Did you see
Yes.
that? Okay. Can you give me an example of how a pool operator can shift gas purchases to their financial advantage if a cash-out balancing provision isn't used?
Well, certainly. You could, in 1 month, if you're anticipating a low or a high price, then you could send less gas than you anticipate needing or more gas than you anticipate needing. And then in the following month, when you would anticipate prices to normalize or shift, you would make up the difference then with more or less expensive gas, depending on which way it might be an advantage. And actually, under the current system, that could even happen within a month, since the Empire balances their transportation customers, all of them, including the schools, on a monthly basis. Within a month, if you're saying, I'm going to have high prices tomorrow or the next couple of days, but by the end of the month, they're probably going to drop again. Well, I can short now and then make up the difference later in the month, not have an imbalance or have a smaller imbalance, but still take advantage of that price difference between today and what later.
Okay, thank you. And then finally, do you have a copy of section 393-310 in front of you?
I can get it.
I believe it's in Mr. Irvin Sr.'s corrected rebuttal as Appendix 1, if that helps.
Yes, I have it.
Okay, thank you. At paragraph 5 of that statute, it states that the aggregation program will not have any negative financial impact on the gas corporation, its other customers, or local taxing authorities, and that the aggregation charge is sufficient to generate revenue at least equal to all incremental costs caused by the aggregation program. What is your understanding of the phrase "at least equal to all incremental costs"?
My understanding of that is that should recover at least enough revenue to cover the cost of administering this program.
What's your understanding of the phrase incremental cost in that statute?
It would be additional cost above and beyond the service they're already providing for transportation customers.
All right, thank you. I think those are all the questions that I have. Let me see if we have any recross based on my questions. Any questions from public counsel?
No, thank you.
MECG?
No, thank you, Judge.
Empire District Gas?
No, thank you, Judge.
MSBA? All right, thank you. I believe that then concludes Mr. Patterson's examination. Thank you, sir. You may step down.
Judge, briefly,
sorry,
I just had
redirect.
probably one or two
I'm
redirect
sorry, Ms.
questions.
Myers, my mistake.
Not a problem. Thank you, Mr. Patterson. Just quickly, Mr. Brownlee had asked you if you were familiar with what he called the statute, and I think the judge referred to that as Section 393.310. Is that your understanding of what the statute is that Mr. Brownlee was referring to?
Yes.
Okay. And I think Mr. Brownlee asked you several questions about, if cash outs were proven to be inconsistent with the statute, would staff still support them? Are cash outs mentioned anywhere in the statute?
No.
No. And Mr. Brownlee referred to it being at cost. Are you familiar with the language? And I believe it is in paragraph 2. Provide for the resale of such natural gas supplies, including related transportation service costs, to the eligible school entities at the gas corporation's cost of purchasing of such gas supplies and transportation, plus all applicable distribution costs, plus an aggregation and balancing fee to be determined by the commission. Is that an accurate reading of the statute?
Yes.
All right. Thank you. That's all the questions I had for you. Thank you, Mr. Patterson.
Ms. Myers, thank you. I apologize for the oversight. Now, I believe we're done with the examination of Mr. Patterson. And you may step down, sir. Thank you very much. And I believe that then concludes the evidentiary hearing, and we will now proceed to present on-record presentation on the stipulation. And unless the parties wish to go otherwise, I would plan to simply go in the same order as the order of opening statements and let parties just tell me what they want to tell me about the stipulation. Mr. Brownlee.
Yeah, if we can take 1 minute to be excused, the schools
Oh,
are
sure.
not part of this.
Sure.
And, I think if we can
So I can close this file out.
We don't have any issue with any of the further proceedings, and we'd like to be excused if we could.
We certainly can, and we'll take, I guess, just to allow for people who don't want to make a presentation to leave, we'll take a brief recess for about 10 minutes. And that way people can move along as they need to, and we'll go back on the record at 10 after 11. All right, we are off the record. Good morning. We have concluded the evidentiary hearing and will now proceed to parties' statements on the stipulation. And unless the parties prefer otherwise, I'll just plan to go in the same order as the order of opening statements. And Mr. Fisher's raring to go at the podium. So anything further from council before we hear from council on the stipulation? All right, Mr. Fisher, when you're ready, sir.
Thank you, Judge. For the record, this is Jim Fisher. I've also got on the line, I think on the WebEx, Diana Carter. Dana Liner is on the call, and I believe I saw Nate Hackney, who are also company witnesses in the case. They're available for the commission if you would happen to have questions that I can't answer. I'm happy to proceed however you'd like. I can just take your questions, or I can summarize the stip if you prefer to do it that way. But
I'm unaware of any questions that the bench has right now. I think I just prefer an overview and see
okay,
if we get any questions
that sounds
later.
good.
Thank you.
Back in August of 2021, the company filed a rate case, a general rate case, and the increase was proposed to be $1.36 million. They hadn't had a rate case for about 10 years, so it's been quite some time. The stipulation and agreement the parties have agreed to a $1 million revenue requirement. That's a little over 3% with gas revenues, or about 4.88% without gas revenues calculated. The billing determinants, we agreed to use the staff's updated billing determinants. There's a section on pensions and OPEBs, which I believe is pretty standard. Unprotected excess ADIT, we've agreed to return the unprotected excess back to the customers over a 3-year period, as was recommended by the staff witness. We are incorporating the staff's rate base number, the original cost rate base at $65.7 million. And that's as of the in-service date of September 30, 2021. Depreciation rates were essentially the staff's as well. Then on class allocations and rate design, the various customer representatives in the company agreed to spread the increase, with the exception of the residential rate class, which the customer charge is going to remain the same. The increase otherwise will be spread equally among all the rate elements. One of the things that is happening is, as you know, the taxes had a rider on it to reflect the reductions that occurred several years ago. We're canceling that. It's all been baked into the overall revenue requirements, so we don't need to deal with taxes. Implementation of the rider, the WNAR rider, one of the goals of the company was to get a weather clause that is more consistent with the Mid-States operation. And this weather clause is not exactly the same, but it's quite similar, and we will be implementing that if this is approved. Then there are also some low-income assistance programs that are identified on page 5 and 6. They're fairly standard to programs that the company has had in the past and other companies have recently had as far as weatherization goes. The critical needs program, that's a new one for me, and that was proposed by Public Counsel. The Empire District Electric Company had agreed in their electric case to develop and implement a critical needs program. We would like to join in that effort on the gas side, and we've allocated $30,000 to be split 50-50 between the customers of the company on that. This company does not have an infrastructure system replacement surcharge, but now that we've completed a rate case, they will be eligible to look at that in the future. And for that purpose, we have designated a pre-tax weighted cost of capital to be used in that SRIS at 8%. There's some credit card fees that are being waived, late payment fees that are being reduced to 0.25% per year, or 0.25% per month. There's an energy efficiency program that they're reworking a little bit. It's basically the same programs, but they're rebranding some things. And with that, I'd be happy to answer your questions.
Mr. Fisher, thank you. I may have a few questions. Let me see if we have any bench questions. I believe Commissioner Holzman may still be with us, and I want to give him the opportunity to ask questions if he has any.
No questions, Judge.
Right, Commissioner, thank you. And this is for you, Mr. Fisher, or anybody else from the company, or frankly, anybody else who can answer. It's my understanding from the stipulation that of the $1 million increase, that roughly $700,000 of that is going to be assigned to the residential rate class. Is that correct? Was it like
Yeah,
698,000 or thereabouts?
on page 4, there's a list of the revenue responsibility increase is just about 700,000, 698,051.
Okay, and the company has roughly 38,000 residential customers. Is that accurate?
I'd have to confirm that, Judge. I'm not sure. Dana or Diana or Nate, do you know the answer to that? I think that's right.
I mean, if I recall correctly, you have roughly 44,000 customers, and about 87% are residential, and that was just kind of my
That sounds
math.
correct. I'd have to check
Okay.
for sure.
And so with that being the
Yes,
case.
I believe that's correct, Judge. This is Diana Carter.
Right, Ms. Carter, thank you. So with my math, that would be an average increase for each residential customer of about $18 a year. Does that sound accurate?
5.6%, I can say that.
I mean, I'm simply dividing the roughly 700,000 by
Yeah,
38,000.
the math seems to work.
Okay.
Yep.
Or then in other words, roughly $1.50 per month average? I'm just trying to get my arms around.
Yes, I think that's
the
correct.
residential impact. Okay. And if somebody has some, thinks that I've missed this, please let me know. But I'm just kind of trying to see what the residential impact is of this stipulation. So those are really all the questions I have, Mr. Fisher. Thank you so much.
Thank you.
Anything else from the company? No. All right. Staff, Ms. Myers, when you're ready.
Good almost afternoon, and may it please the commission. This is Jamie Myers on behalf of staff. I will keep my remarks very brief. I think Mr. Fisher did a good job of walking through the stipulation and agreement. I will say staff is a signatory to this agreement. We do believe it is a reasonable resolution of all the issues contained in the document. We would recommend that the commission approve this stipulation and agreement. In addition to myself, there are several other staff members present if the commission would have questions. And that's all I have, and thank you.
All right, Ms. Myers, thank you. Commissioner Holzman, any questions for staff? All right, hearing nothing, I don't have any questions. Ms. Myers, thank you so much.
Thank you.
Mr. Williams, any remarks?
May it please the commission, Nathan Williams, appearing on behalf of the Office of the Public Counsel. We support the stipulation agreement. We're a signatory to it. We believe it's a reasonable outcome and the aspects that it addresses in this rate case.
Mr. Williams, thank you. I don't think I have any questions. Commissioner Holzman, any questions for Public Counsel?
No questions.
All right, thank you. Mr. Williams, thank you. Mr. Opitz, any comments?
Your Honor, I have no additional comments. MECG is a signatory, and I ask the commission approve the stipulation.
All right, thank you, Mr. Opitz. Commissioner Holzman, any questions for MECG?
No questions.
Right now, I don't have any questions. Thank you. I believe that concludes then the on-the-record presentation on the stipulation. Is there anything else further council wishes to address?
Judge, I know there's a briefing schedule already in the procedural schedule. Do you want to stay with that, or?
I will probably accelerate it. I want to be sure the transcript gets in before I issue a briefing schedule. I'm probably looking at, once the transcript is filed, probably somewhere in the neighborhood of 10 days to 2 weeks for you to file briefs, unless that causes you any concern. I don't want to unduly delay this case since most of it's settled. I'd like to get this in front of the commission and get it resolved. And then, And if you don't know now, it's okay. Do you think you'd still like reply briefs since the issues are limited, or do you find them necessary? I'm happy to do either.
I think we'd like to have a brief reply, but to accelerate the briefings, that's not a problem from our
Okay.
standpoint.
Very good, thank you. Anything else from council or from the bench? All right, hearing nothing else, we are off the record in file number GR 2021-0320. Thank you so much.
Thank you, Judge.
Thank you, Judge.
Commissioner Olson's first name?